Hi, it's Guy DiMartino, estate planning lawyer in Northwest Indiana. And today I have the pleasure of speaking with an estate planning lawyer in Portland, Oregon, Don Rolfe. Don, can you introduce yourself, please?
Sure. Hey, Guy, thanks for having me. First off, my name is Don Rolfe. I'm the owner and founder of Northwest Legal Planning. It's an estate planning and probate law firm located just outside of Portland, Oregon, in a small town called West Lynn on the Willamette River. And for the past, I want to say, 8 years of my attorney life, I have been practicing solely in estate planning and estate administration. Before that, I was a litigator. Kind of moved away from that because I wanted to enjoy working with my clients rather than not enjoy working and fighting with everyone. So, and it's been very rewarding.
So I come from a litigation background also, and I deal a lot of times with estates and trusts and issues like that have gone bad. So I think today it would probably be a pretty good idea for us to, talk about, we could talk, number one, about estate planning for the time when you're alive, estate planning when you pass away, but more importantly, some of the biggest mistakes that we see which cause a rift between families and what families go through sometimes because things are not clear or the intent of the person who wrote the documents was not quite clear. Does that work for you?
Absolutely. Absolutely.
So let's talk about first, everybody when they look at estate planning, they go ahead and they think, well, it's only about when you die. And yes, we all are going to die and we all have to pay taxes. But so many times people come into my office with, fights that are already starting and problems that are already starting when folks are alive, when folks get sick, dealing with a business, or if when somebody gets older and has to go into a nursing home. So from an estate planning perspective, when somebody comes into your office, how do you approach these issues before they even happen and end up at my office?
Okay. Well, number one, I think I try to tell people that their life is not just this simple monolithic thing. They have different sections of their life that they need to worry about. One of them, we can talk about healthcare. That's a section of your life. You have assets and your finances, and then you have distribution of assets after you're gone. But I think while you're alive, one of the things that comes up and can be a big problem is if you haven't selected the people to make healthcare decisions for you, and you come to that point where you're incapacitated, and that requires appointment of a guardian or a conservator to make those decisions for you. And that can cause a rift in the family because, brothers and sisters, they may not get along and they may both want to make decisions for dad. And then at the same time, that person hasn't made those healthcare decisions. They probably also haven't made financial decisions as to who's going to be managing their assets when they're incapacitated. And then you have the same fight again. So when I work with people, I try to take a holistic approach to the estate planning and make sure that we're planning for all of those different aspects of their life, both while they're doing well, incapacitated, and after they have passed away.
What do you do with folks who come to you and say this, Don? And this is something that I deal with. Well, I don't want to make the decision. I want my children to make these healthcare decisions. And then I say, a lot of times I ask them, you're talking about multiple people making these decisions? What do you say to folks, or what type of advice can you give along these lines?
Well, I kind of, and maybe this is a bad analogy, but I kind of look at it or tell them this is kind of like a kitchen, and you can only have one head chef. You can have sous chefs, and they can help the chef make the decision what's going to go on the menu, what the ultimate final meal is going to look like. And like I said, this may be a horrible analogy, but you need to have that one person in charge, and they need to pick somebody who will take into account what others are saying, but also have the fortitude to make the decision on their own. And that's how I advise my people, my clients. And a lot of times it's very difficult for people to say, well, I have 3 kids and I love them all equally and they all love me equally and I want them all to share in it. But really, you can only have that one head chef to make the final decision.
Especially when it comes to healthcare decisions, because people have different personalities. One of your children who could be really good with finances might not be the person who's really good with healthcare decisions, because this son or this daughter can just be such an emotional person, or might have a spouse that's poking them about something. And sometimes the decision that will come out can either get, the kids can fight over what's going to happen, or it's really not what your wishes are regarding your health care.
Right. And I think most of the people that I work with, even if they are conflicted at the beginning, once they really think about who their children are and they understand the personalities, they understand what their children's strengths are, they come to that decision fairly easily after we've discussed it and talked about it. They're like, I really think Sue would be the best one to make my healthcare choices, my daughter, and my son definitely would be the one for my finances, or whatever it is. They know in their hearts. It's just hard to make that, pull the trigger on making that decision sometimes.
So another area where I see a lot of folks where strife starts to begin when their parents get older or very close to the time that the parent would pass away has to do with bank accounts. And it usually has to do when there's kids that live out of state, and there's a kid that goes ahead and is really close and takes care of mom or dad when mom and dad are aging. And so what happens, in order for convenience, they go ahead and they put that child as a co-owner on the bank account. Can you talk to that issue, my friend?
I just met with someone this morning. We were consulting on a probate that we're going to be opening next week. And the gentleman that I'm meeting with, his youngest son lived with mom until she passed away. And before mom passed away, youngest son actually cleared out all of the bank accounts because he was a co-owner on them. And while it wasn't a great sum of money, we're talking maybe $1,500 in cash, it definitely is a big concern. And the way that I advise people to avoid that is, number one, if we're doing trust-based planning, we're going to put those accounts into trust, and only, people that are qualified as successor trustees are going to be able to access them, whether those are successor trustees while you're incapacitated or after death. And then if we're doing will-based estate planning, I advise them that if you want someone else to have access to your account, you're going to use your durable power of attorney. You're going to take it to the bank. You're going to explain to them who has access and when they would have access, only after you're incapacitated. And it's best to go down and do that while you still have capacities, because sometimes the banks want you to sign their own form of power of attorney. But make sure that it's only for access after you're incapacitated. Having that joint ownership, number one, it causes a problem because that's a present day gift. If I put you, Guy, on my bank account, that's a gift.
Will you? Can you?
As long as you're going to make deposits, I will. But that could be a present day gift right now that could be taxable, depending upon the value of it. And it's not a very clean way of handling your assets. So I really think that that the best way to handle it is through the power of attorney or a trust, and educating people as to what the downsides are of having joint ownership.
Well, so say the bank account for the person that you were dealing with just recently had $50,000 in there. And in speaking with the one son who came to see you, that mom or dad really wanted those monies split up equally between the kids. But because there was the other son was a co-owner on the account, under the law, he has a right to those funds. And that's not what mom or dad wanted.
Right. And at that point, it really doesn't matter what mom and dad wanted. Unfortunately, as you said, under the law, son that was on the co-owner of the account, he owns that money before mom and dad passed away, and he owns the money after mom and dad passed away. And unfortunately, I have seen that numerous times, where there are actually the estate ends up being upside down because a son or a daughter was on the account. They got all of the cash, and then all that's left is debts. And I have actually the only people I have actually seen able to get back any of that money are creditors. I have seen creditors come in and be able to take some of that money back, saying that it's essentially a fraudulent transfer in order to avoid creditors. But I have never seen other heirs be able to bring that money back.
Yep, I'm with you. So one of the ways that you can stop that situation from happening is a power of attorney.
Correct.
Right. Another way would be, I don't know if you have them in Oregon, would be either a TOD, a transfer on death, or a pay on death account, and you can leave it to your children equally.
Correct. Yeah, you can have more than one beneficiary. I'm still not a huge fan of those because of the fact that you don't know what your final bills are going to be, and that could raise some ugly heads with creditors against the estate, saying, "Hey, this $50,000 cash that was in this account went to the 3 kids, and now there's nothing to pay us for all of the work we did, for your end of life medical treatment or something like that."
Yeah, it definitely could cause an issue with creditors, and not so much with the kids with that type of fix.
Right. So that's kind of an intermediary type solution to the problem. I think that it's better than obviously adding the kids as owners of the account, but it's not as good as we could do. But it depends on where the client's threshold for risk and what they want to how involved they want their estate plan to be as well.
So the two things that we discussed when somebody is alive, which, it could happen to any one of us. We can be temporarily incapacitated. Maybe we go in for surgery, have to go into a nursing home, can't handle our banking, can't handle paying our bills. And if, we have a power of attorney, our power of attorney can go ahead and handle those things for us. What about now, and what problems do you see with a will-based plan that sometimes folks do not think about?
I think number one is making sure that the agent you've selected is going to have access to your accounts and be able to deal with both creditors and people holding your assets. So, just because you have a durable power of attorney doesn't mean that the person that's named in there as your agent is going to have access to your bank account. It's solely at the whim of the bank. So if you go down, for instance, they go down to Wells Fargo where you have your account. Wells Fargo says, well, this power of attorney was signed more than 12 months ago. We're not going to accept it. That can be a big problem because you think that you have solved it by having the durable power of attorney, but then the bank has frustrated that. So if you're going to be relying on a will-based plan with the power of attorney, it's always advisable to go down and take that document to the bank and get it on file so they have it, and it's in their records and they're going to accept it before it needs to be used. The other issue is just it's durable power of attorney is, it's a statutory type document. It's allowed under the laws, but there is nothing that forces a third party to have to deal with you. So it's not just the banks, it's every third party that's out there that while you're incapacitated, there's absolutely no force of law that says that they have to deal with the person that you've named as your agent. So really just getting that in the hands of as many third parties to work with as possible before you become incapacitated is very, very important.
And, banks are sticklers, especially these national banks. I'm dealing with a probate now where I am the PR and I'm dealing with multiple states. I can't tell you the obstacles that I've had with these banks. And my response to them is, okay, I'll see you in court. I have to file everything to do to get into a safe deposit box. I got to file a motion in the court to get a drilling order and, for the court to name an agent so I don't have to go to another state in that agent, just to get beneficiary designations on a bank account recently. They wouldn't give it to me. I went in there with my letters of administration. I went certified copy, and they say no. So banks are weird because they're so highly regulated And they're so fearful that they are going to be on the line or the hook, that if you walk in there with a power of attorney that you might have pulled offline, they're going to look at that and they're going to say, well, I really want our power of attorney signed.
Right.
And if you can't do it, then you're in trouble.
And, one of the things that I actually put in my powers of attorney is it grants the agent the authority to sign the institution's power of attorney, which I don't know if that's going to hold up, but it's something that, we put in there to say, hey, not only do I have the power as the agent, but I also have the power to sign whatever form you want me to sign that says I have the authority to be here. But banks, yeah, you're right. The big national banks are really difficult to deal with sometimes. And one of the things that I really dislike that they say is they say, well, that's our policy. That's our policy. And they're big national banks, right? They're huge monolith corporations. They don't have policies that aren't written down, right? If it's not written down, it's not a policy. So I always ask, or I tell my clients to ask, could I have a copy of your policy? And they will say that they have these policies, but they're not written down. They can't get you a copy of it. So it's really, I think a lot of times it's just based upon, that branch's, what they do, how they handle powers of attorney or certificates of trust or all of those sorts of things. I have actually had clients, and this was, I won't say the bank, but they stopped at a branch to change the name on their accounts when we created their trust, took in their certificate of trust, and the bank said, we absolutely cannot do that. They drove 2 miles down the road to the next branch and got it done that afternoon at the next branch.
Yeah,
it's crazy. But I do advise my clients that if they get the policy line, to ask for a copy of the policy, because they're a customer, they're a client. They should be able to have those policies in front of them so they know who they're dealing with and exactly what the rules are.
Absolutely. So on the will side, the biggest strife that I see is when wills are changed close to the person's time of death, within a few months or a few weeks. And the typical scenario that I see, because I usually see things when things have broken down, is that you have one beneficiary who's spending all their time, all their energy taking care of, their aging parent or their aging grandparent. And then they get in a relationship where they become sort of codependent, and whether that child talked the person into changing the will, or because of all the work that the person is doing, they want to go ahead at the close to their time of death and change the will to give this person a little more.
Right.
This seems to be a very big problem, and it usually happens when other heirs are out of state.
Right.
So do you have these discussions in your planning meetings with folks? Have you had like heirs call you and say, hey, I want to bring mom or dad in to change their will? What are your recommendations, and what do you see and what do you say with those situations?
So I've definitely had sons and daughters calling and saying, hey, I need to get mom in because, she's getting sick and she wants to change her will and we need to get her to come in. And I say, absolutely, let's sign her up. Can mom get in on her own, or are you going to bring her in? Just to let you know, when you do bring her in, I'm going to meet with mom by myself.
Yep.
Because she would be the client, and I need to explain some things to her about attorney-client confidentiality. And if she would like you to come back in after I've talked to her for a while, then absolutely you're welcome to come back in, but it's up to her. And I find that 9 out of 10 of those do not set up an appointment with me because that's not what they want to hear. But in my practice, I want to make sure that whoever's estate I am working on is the one making the decisions and the one driving the boat.
Because if things go bad and you did that codicil or you did a new will, at that point in time, you are going to become a witness in that case regarding any undue influence.
Correct.
That's the term. You have somebody who's a fiduciary, like an heir who's taking care of them, and they drive them to your office. They sit in the room, they talk for them. There's a problem with that.
And recently I have had several appointments scheduled by children whose parents do not speak English, Korean or Spanish, Japanese, and I don't speak any of those other languages. And I have to explain to them when they come in, I can't communicate with your parent through you because you're not a disinterested party. We're going to have an interpreter come in, and at that point, I most of the time they do not come back. And I'm happy to refer them to attorneys that are native speakers of those languages, because I think it's very important. But I think that they're trying to, and I hate to say this, but I think that some people are trying to kind of work the system a little bit. Unfortunately, I'm not saying that of all of them. I would say very few of them are trying to work the system, but I think it does definitely happen. And I can't be a participant in that.
So let's wrap up with another issue that I see with wills, Don, and maybe you can give some advice. And this is the setup, and this is the issue, and it just happens. And that is, sometimes the more kids you have in a family, the more risk you have of having a black sheep kids, for lack of a better term. And you see it all the time. And you have parents who come into you and they want to disinherit one or more of their children.
Mm-hmm.
And what do you normally recommend when that's the first thing out of a client's mouth? And how do you shore up your documents, or to really show that it was the parent's intent to disinherit the child so that it can't be challenged later based on undue influence or something along those lines? Has that happened to you?
Well, I've definitely had parents that want to disinherit. And, it's in my documents, basically what we say is, I want to treat this child as though they've predeceased me. I'm not leaving anything for them in my estate. As far as ensuring that there's not going to be a claim of undue influence, I mean, you really can't. I mean, anybody can make a claim for anything. But we do our best to make sure that we have independent witnesses in those cases that are not, other beneficiaries that will be inheriting. Because here in Oregon, a beneficiary can witness a will. That doesn't exclude or doesn't cause a problem. But if we're disinheriting other individuals, we probably want to have completely independent witnesses to make sure that there isn't some thought of some collusion later when we're administering the will.
Have you taken the step, or will you take the step? I'm believing that I'm going to do this, and this might be an option for a number of folks, to actually videotape the signing and videotape the actual person, putting their wishes on video and the reason for it.
I haven't thought about videotaping. I do sometimes have clients write letters that could be submitted as evidence in the future. One area that I have clients write letters is if there are individuals that they would never want to have as guardians for their minor children. I will have them write a letter, and we will put that in the file. And then so that it's not a public thing. It's not in the will that says, I would never want my brother Joe to be the guardian of my children, right? Because do you really want to make that public? However, we put the will in the file, or we put this letter in the file. It says, I would never want to have Joe be the guardian of my children because of X, Y, Z, so on and so on and so forth. And so if at some point in the future Joe tries to challenge and say, I should be the guardian, we have that letter that we could show Joe, and ultimately we could make it public with the court. I think you can do the same sort of thing if you're disinheriting children. You could put a letter in the file. You don't have to put it right into the will, but it could be some sort of supplementary evidence later that could be submitted to the court if it became necessary. I don't want, I really wouldn't want to get into, if I was going to start recording my signings, I would want to do it for every single one, because I would never want there to be a question of, well, why did you record this one? Did you think there was an issue?
Or even better yet, it doesn't have to be done in your office. You know, when the parent or the person gets home, they can have their own recording and they can keep it in a safe place, you know, given an explanation. Because the thing that happens in all these cases is there is a lack of communication, or some folks just don't understand about what's going on. And sometimes these conversations need to be difficult conversations, and sometimes people would just rather put them off than have the conversations. Because if everybody knows, then, you know, everybody knows, and you can try to handle the situation before it blows up. It's like anything else. You stick your head in the ground and there could be a problem.
Right. Those conversations are very difficult to have. But unfortunately, when we're talking about, you know, disinheriting people, a lot of times there is no way to have a communication with them. You know, they're gone, right? They're completely out of the picture until such time as mom or dad pass away, and then they might work their way back in. But you know, I guess having the conversation with the rest of the family as to why, but that's, you know, obviously a difficult conversation as well.
It is, but in a lot of the families, a lot of times the other family members already know why.
Right. They do.
Because, yeah. Well, this is great. Thanks so much for sharing your knowledge. If
Absolutely.
anybody is in the Portland area and they would, you know, like to get in touch with you, or they have any questions about an estate planning matter, how would they go about doing that?
The best place to find me is at my website, and it's nwlplanning.com, like northwestlegalplanning.com. They can also put that in basically anywhere, YouTube, Facebook, NWL Planning, and find me talking about estate planning a lot online. And you know, if they want to chat, they can make an appointment with me right on my website, and get on the phone or come in for a chance to get answers to their estate planning questions.
Thanks for your expertise, Don.
Absolutely. Thank you.